Good morning. I hope you all can hear me. We've had some technical difficulties, or I've had some technical difficulties this morning. So I'm going to look to Mike and say, Mike, if you can hear me, can you give me the thumbs up? Excellent. We're on our way. Good morning. You all are here to participate in a webinar on Maine's earned paid leave law. As many of you know, this law was passed in 2019, and the Maine Department of Labor undertook a long rulemaking process to try and put a finer point on the language that was left ambiguous in the actual statute. And after nearly a year of working, those rules recently came out, and we are very pleased to be joined here this morning by a number of folks from the Maine Department of Labor to present some information on it, but also more importantly to answer your questions, because we know there are a lot of them. Our program this morning is sponsored by Bangor Savings Bank, Central Maine Power, and Eaton Peabody. And we want to thank those sponsors. We have a large crowd this morning. This does not surprise me. Our presenters today are Mike Rowland, who's the director of the Bureau of Labor Standards, Scott Cottonauer, who's the director of the Wage and Hour Division, and we have two folks from Maine's Bureau of Unemployment Insurance, Jeff Braun and Michelle Copperwaite, who are also with us to try and answer questions related to unemployment insurance. The way this works and the way we've done this in the past is that there will be a presentation, and then folks will be able to answer questions. Everyone is muted and everybody will stay muted, but at the bottom of Zoom, and I'm sure most of you have done enough of these to know, there's a chat function where you can input your questions. The folks from the Department of Labor have asked that we try and answer questions as we go along. If there's something they say that invokes a question, to go ahead and input it, and they'll answer them and then proceed. But again, part of the main function of being here this morning is to have folks ask questions and try and get them answered. So with that, again, I want to thank everybody for being here this morning, and I'm going to turn it over to Mike to begin the presentation this morning.
Got my mute button, and can everybody hear me? Okay, I see nodding heads. Yeah, I'm Mike Rowland with the Department of Labor, the Director of the Bureau of Labor Standards, and Scott Cottonauer is with me again. Those of you, I see some familiar faces that were on the last call. You might remember that on that call, we tried to go quickly through the statute and the rules that have now been finalized, and go straight to your questions, because we've tried to anticipate what the questions might be and provide answers. I hope that all of you have or will soon look at our webpage, which contains a long and growing list of frequently asked questions. But again, we're anticipating and we can't be sure what they all are. So the last session we had about a week ago, some very good questions were asked on several subjects, to which we didn't have as complete an answer as we would have liked, which is why we've added two specialists, one of them, or both of them, from the Bureau of Unemployment Compensation, who are joining us. That's Jeff Braun and Michelle Copperwaite. I hope I'm pronouncing that right, Michelle. To help us with those questions that involve definitions in the unemployment insurance statutes. Now, I want to clarify, they're not here to answer questions about unemployment insurance. They do that, I'd probably say 99% of their time, but they're dedicating this time to helping us in the Bureau of Labor Standards answer those questions that relate to the Employment Security Act. And that's the act that governs unemployment insurance. And the reason for that is because in the statute that was created for earned paid leave, there are references in the definitions of employment and employer and employee and seasonality. There are references to that Employment Security Act. So I want to thank Jeff and Michelle for being willing to join us and add, hopefully, some very important content to what we can provide to you. Now, there are, I guess I'm going to assume at the outset that most of you have familiarized yourself somewhat with the statute, the new statute, which is very brief and, as Peter said, required some clarification, and the rules, which are our effort to clarify some of what's in that statute and make it more possible for you folks and your workers, your employees, and others to understand what the law requires and how we at the Bureau will be implementing and enforcing the new statute. So that's just a little bit of background. I'm gonna raise a couple of the questions that I know were raised last time, about a week ago, when we first had this conversation with a slightly different group, and toss it over to either Scott or to Jeff and Michelle to answer, to address some of the questions that came up. And one of them had to do with existing employee leave policies that might already be in existence at one of your companies. We took that question. I think we answered it reasonably well, but in the meantime, we've added frequently asked questions to our fact document on that subject. And Scott, if you could just go into a little bit of detail about what will be required or allowed with respect to existing policies and what would be allowed by an employer as far as granting or providing leave if they have, for instance, sick leave policies separately from vacation policies and our unpaid leave. Can you go into that a little bit, Scott?
Sure. All right, so I just want to touch on some brief points about the law, just as an overview. This law goes into effect January 1st, 2021. It's going to include all industries for employers with more than 10 employees in Maine for more than 120 calendar days in a year. It does not include seasonal industries as defined, as Mike indicated, by the unemployment tax law, Title 26, Section 1251. It includes all employees that are full-time, part-time, temporary, per diem, etc. The employees are going to be able to, or will begin accruing 1 hour of earned paid leave for every 40 hours that they work, for a maximum of 40 hours in any defined year. Employers can use their discretion to front load the balance or to front load the earned paid leave at the beginning of the year. That's a decision they can make. Employers that allow employees to use earned paid leave before it's accrued can withhold or prorate their last paycheck. If they used all of the earned paid leave before they left and hadn't and wouldn't have accrued it by then, the employer can prorate and deduct the amount that was advanced. Employers aren't going to be required to allow employees to use the earned paid leave until they've been employed for at least 120 days. That's from the start of their employment. So if you have a new employee come on January 1st, they're going to start accruing earned paid leave from the moment they start working. But they're not, you don't have to allow them to use it until 120 days has passed. Employees are going to be able to use this earned paid leave for any reason, whether it's sick, personal, vacation, whatever the case may be. Employers can require that employees give up to a full week advance notice to use the earned paid leave for reasons other than an illness, emergency, or sudden necessity. So if they're discretionary use, they want to take a vacation day, you can require that they give you at least a 4 day, or I should say, at the most a 4-week advance notice to use that leave. Now, Mike mentioned there were questions last week about how does this affect existing policies? If an employer has a policy for any type of paid time off, but they don't have a policy for earned paid leave at this point, if your policy regarding paid time off stipulates that the balance of that paid time off is paid at the time of separation, then the earned paid leave will also need to be paid. If you have a policy that says the paid time off is not paid, then you're not obligated to pay the earned paid leave. Nothing prohibits an employer from establishing different policies for different types of leave for any reason. So you could have a sick leave policy, you could have a vacation policy, and it's probably beneficial at this point to think about creating an earned paid leave policy. If you create an earned paid leave policy, whatever terms you establish in that policy, that's what you're going to enforce or abide by. So if the policy says that if the employee has a balance of earned paid leave at the time of separation and they leave on good terms, we will pay the balance out. If that's the case, it's considered the same as wages and does need to be paid on the final paycheck. You could have a policy that says, just across the board that there is no cash value to the earned paid leave when employment ends, at which point you're not obligated to pay it. However, if the employee returns to work for you within a year, if the balance was not paid out, that balance will then carry back over to the new employment. That's within a year. If they return after a year, they're going to start accruing from that new date going forward. So our website has a lot of information. One link is to the frequently asked questions and answers that Mike alluded to. Last week, there was one of the questions on the website indicated or was vague when it comes to can the employer establish multiple policies for different types of leave. After the meeting we had last week, we revisited that question and wrote what I hope is a clear answer, which states that yes, employers can establish different policies for different types of leave. Each policy is going to stand alone. What the takeaway is, if you don't have an earned paid leave policy, but you have a paid time off policy, the terms of that paid time off policy are going to apply to the earned paid leave. Okay.
So we have 4 or 5 questions already. And I'm going to throw them out to whoever wants to answer it. Some of them may be UI questions because it deals with seasonality. So the first question is, our agency does a 2 to 3 week orientation before classifying the new employee as a full or a part-time status. Do we start the 120-day counting on the first day of employment or after the employee goes into a work status?
Yeah, no, great question. The orientation is considered work time. So I'll give an example. If you are looking to hire an employee, you interview the employee. In that interview, you say, we like you, we want to hire you. They accept the position, and you say, okay, at this point, we're going to have you fill out some employment paperwork before you leave and come back in 2 weeks when you start. If they fill out paperwork at that interview, that's the start of the employment, because that filling out paperwork is considered work time. Okay? But if you say we want to extend an offer of employment to you and they accept, but they say I can't start for 2 weeks and nothing is done at that point, because in 2 weeks they come back, that day when they start to do any type of work, filling out paperwork, attending the orientation, that's the start of the employment. So the 120-day clock starts at that point.
When the employer creates a policy for the earned paid leave, do we have the option of having a use it or lose it as of 12/31/2021, or do we have to carry the earned paid leave over to the next year?
All right. An employer cannot dictate or mandate that the use it or lose it from year to year. Now, the employer, the law states that the employer is not obligated to carry over more than 40 hours. Okay, so they're just, if they already have 40 hours and they didn't use it at the start of the new year, they're not accruing any new additional hours. They've already got their 40 hours. It has to carry with it. If the employee requests, hey, I didn't use my time, I'd like to have it paid out, would you pay it out? If it's the employee asking the question, the employer can pay it out. At that point, the employer is not requiring it. The employer is using their discretion and agrees to the request, pays it out. At the start of the new year, they have no time. They're going to start accruing again at that point. 1 hour for every 40 hours worked.
Okay. Here's a seasonality question. If you have 50 employees for less than 26 weeks, but more than 120 days, and are open for less than 26 weeks, but you keep 6 year-round staff, would you be classified as a seasonal employer and not be required to provide the leave to 6, or provide the leave to all 56?
Right, I think that's a question for Jeff and Michelle. When they reference less than 26 weeks, I think the seasonality period, it has to be more than 26 weeks, but I'll pass it over to Jeff or Michelle.
Well, I guess I'd just like to point out or clarify that when we talk about seasonality, seasonality is defined by the legislature. It is not a business that is open less than a year or not open all year round. So I guess what I would do is take this question and assume that you fall into one of the categories defined by the legislature. And if you are defined as seasonal, then I guess I would kick it back to Scott then to answer that.
The statute says a number of employees for 120 days without reference to seasonal, Scott. I believe it's any employee for that period of time.
So, right. So if the business is deemed seasonal by unemployment standards, those employees are exempt from earned paid leave law. There's going to be a confusion, or there's going to be a hiccup if the employer then employs that employee outside of the seasonal period.
So I've been told this is a hotel situation, for example.
Okay, so what I mentioned, wanted to mention is that there's also going to be businesses that operate both in season, have a seasonal period, and operate all year long. The ski resorts, for instance, may have employment or be classified as a year-round business, but they also have a specific seasonal period with seasonal employees for that period. And whether or not those individuals count towards the 10 or more, I mean the more than 10 for 120 calendar days in a year, is going to depend if they're working outside of the season or not.
So basically the question is, you have 50 people for less than 26 weeks, but more than 120 days.
Right.
And you're open for less than 26 weeks. In that situation, would you be required to pay the leave or not pay the leave to those 50 employees?
If the business is deemed seasonal, then no. If it's not deemed seasonal, then yes.
So just oh, sorry. Go ahead, Scott.
Okay. The fact that you're operating less than 26 weeks is one part of the criteria to be possibly classified as seasonal, but there's also another step that they actually have to, that I think Jeff and Michelle can elaborate on. They have to have requested to be seasonal through the Unemployment Commission.
So the 6 year-round staff, would you be required to pay the leave to those 6 year-round staff?
If they only have 6 year-round staff and everybody else, the 50 other employees, are actually seasonal, or meet the definition of seasonal, then those 6 employees would not be entitled to earned paid leave because they haven't met the threshold of more than 10 employees.
Okay. So we've got questions coming fast and furiously now. I knew as soon as like a couple of people got in there, we'd start rolling.
That's good.
Regarding payout at separation, if existing policy pays only a portion of the accrued PTO, can we apply the same partial payout to the new leave?
Yes, whatever terms are established in the policy, you can establish any terms or conditions in the policy. Pay out a portion of it, pay out only under certain conditions, or no payout at all. Whatever the terms are.
They have to mirror.
Yep.
Does an employer have to allow an employee to carry forward unused time at the end of the calendar year into the new year?
I think I touched on that. Yes, they do. They can't demand that there's no rollover or that it has to be paid out. It can be paid out if at the request of the employee.
If an employee works 80 hours in a week, are they entitled to 2 hours of earned paid leave?
Yes, earned paid leave is based on they earn 1 hour for every 40 hours worked. Whether it doesn't matter how quickly they work those 40 hours. If somebody works 60 hours in a week, they're entitled to 1.5 hours, or they have accrued 1.5 hours of earned time at that point. What you want to keep in mind is if they're working overtime, the overtime hours aren't counted at time and a half rate for the accrual piece. It's still hour for hour.
If you offer a position based on passing a background check, does the clock start once the background check is passed?
No, not necessarily, unless the individual has performed any type of service, filled out any required paperwork for the employer, payroll paperwork or anything like that. Then the clock doesn't start until they actually perform some sort of service.
Okay. We currently have a sick leave and vacation leave policy, but neither policy rolls over time. Do we now have to allow up to 40 hours to be rolled over for both policies, or can we pick which policy rolls over?
So if you have a policy for sick and vacation, but there is no rollover, this statute has a floor. The floor is they earn 1 hour. It's going to be at least 1 hour for every 40 hours worked, up to 40 hours in a year, and it's going to carry over year to year. So if they have a policy that is the vacation and sick, or either of them don't carry over, they have to revisit that policy to adjust it for maybe up to 40 hours can be rolled over.
And I believe those 40 hours, or whatever number they are, have to meet the requirements of the Earned Paid Leave Act, which means that they're available for sick or emergency or vacation or any number of different purposes.
Right.
Am I right about that, Scott?
Yep. The use of the leave they have to be available to use it for any reason. So if they only had 2 hours of sick and 38 hours of vacation, if they needed to be out, if they were going to be out sick for a day or 8 hours, the employer can't say, well, you only have 2 hours of sick time and you can't use your vacation time for that purpose. They have to be able to use up to 40 hours for any reason, whether it's sick, personal, or vacation.
I have on some occasions encouraged employers who still separate vacation and sick time to perhaps revisiting that to create a single PTO plan, whether they coalesce the hours or limit the hours, that meets at least the usage standards under this piece of statute. But
Yes. Yeah,
it'll just be easier to maintain.
Absolutely.
Let's see. I think you've answered this, but is the employee earned paid leave in addition to already established PTO policies, or do current policies qualify?
Current policies can qualify as long as the employee can use that time for any reason, and it meets the basic minimums of Uh, they're accruing it 1 hour for every 40 hours worked. They can use it for any reason, up to 40 hours in a year. One thing I didn't touch on is the minimum amount used. Some policies state that an employee has to use a minimum, or if they're going to take time off, it's a minimum of 4 hours, or it could be a minimum of a day. With this law, the increments can't be greater than 1 hour. So the employee needs, if the employee has an emergency, they have a flat tire, they call in, they say, I'm going to be a half hour late, or I'm going to be an hour late. They come in, the employer can't say, well, we're going to dock you 4 hours because that's our policy. They can say, we're going to dock you 1 hour. Okay, it can be 1 hour increments. It can't be greater than 1 hour increments.
It's up to the employee.
Yes.
Above an hour. Yeah, or yeah, above an hour.
Can an employer require the first 40 hours of paid time be designated as earned paid time? I think it says PT. I think they mean paid time, designated as earned paid time.
I'm not sure what they mean by that. Scott,
Yeah, I mean, if they have a policy that provides more than the 40 hours, they can say that we have a PTO policy, the first 40 hours is earned paid time, and ultimately it's going to meet the standard of the law. It can be used for any reason, and it can be used in 1 hour increments.
This is a good question. How will the earned paid leave conflict with workers' comp or disability?
Mike, try that one. I
think
don't,
I don't see the conflict.
Right. I don't know what the conflict would be.
I think they may mean, is there an offset, or that possibility? I mean, with workers' comp, there's a 7-day waiting period before you qualify for benefits. So theoretically, you know, an employee could use the 40 hours of earned paid leave as their during that 7-day waiting period. But I don't know if there's an offset with either comp or disability. That's a question that I think we'd probably have to ask the comp board at a minimum on the workers' comp. Not sure about disability.
Yeah, it would have to be directed towards them. One thing I was thinking of when you just mentioned that is what an employer would not be able to do is if somebody's out on workers' comp, the employer can't say you have to use your earned paid time for, you know, the week or 40 hours of earned paid time while you're on workers' comp. The use of earned paid leave is at the employee's discretion. An employer can't, the employee can't lose a benefit because they're out on workers' comp. I don't know if that's the avenue the question was going down, but it is a concern or an
and on the flip side, the employee doesn't earn paid leave while they're on workers' comp or disability.
That's the other question I was going to ask.
Yeah. Right. No, if they're not working, they're not earning. Leave.
A question regarding carryover. The employees accrue 120 hours of paid time off per year with no carryover into the next year. Under the Maine PTO law, if an employee uses at least 40 hours during the year, do we have to allow any carryover into the next year, or is the carryover requirement satisfied since they used 40 hours?
Based on that example, I would say that the carryover has already been, the requirement has already been met. They've used 40 hours in the year. They're not entitled to any more in that year. There wouldn't be any, if their policy is that there's no rollover at that point, and there's no rollover. The start of the new year, they start accruing time again.
That it would satisfy.
What about summer interns?
Summer interns. So the law applies to every employee, whether they're part-time, full-time. If they're not deemed seasonal by unemployment standard, then they too would be accruing time. Now, if they're only summer interns, are they working 120 days in that first year? If not, then the employer is not obligated to allow them to use any of that time because they haven't met the 120-day requirement. However, if they return to work within the year, so they get done at the end of the summer, they start at the beginning of the next summer, what they accrued then is going to carry over to their new summer intern.
And this is on the assumption that interns are employees, which in most cases they are.
If they're on an unpaid internship, would they accrue?
Scott?
Well, I guess it's going to boil down to Jeff and Michelle. Are unpaid interns considered employees for unemployment standard purposes?
For us, they would not be reported if they're not being paid. We would have to look at it to see if, what they're doing, if it falls into that. But if they're not being paid, then they're not reported on their unemployment tax quarterly reports.
Right. I think and correct me if I'm wrong, I think there may be an exemption for students working at an establishment for educational purposes as a student learner or as an intern. Is there a specific exemption in 1043 for that?
There is if they're working at the school or they're working for the school. There's also, if you're talking about like summer camps, that some do bring in interns. Summer camps are exempt as well.
So I think this is, I looked at this and I hadn't really thought about it until right now, but I think this is a very important question that may need clarification.
Yep.
Many employers get requests from students for internships associated with their college, some of their years in college, junior year in particular, is often very interested in and require kids to have internships. And oftentimes employers can offer an unpaid internship, but not a paid internship. I understand a paid internship because there's remuneration involved. And so it's doing work. But the unpaid one will be important for the students and for the employers to get clarification about. I'm concerned that if it's an unpaid internship and employers are required to provide the leave, that may limit employers' willingness to offer that kind of internships.
Yep.
So that needs to be clarified.
Yep, nope, I understand that, and it is a good question. It is one that we're going to further discuss, and we'll end up putting another frequently asked question on our page to address a specific issue.
I've had this question as well. Are substitutes included in the school system? Are substitutes in the school system included in this law?
They would be. Again, is that substitute going to be working 120 days in a year? If they do, then they would be entitled to whatever they had accrued. If they don't, and they return to substitute within a year from their last date of employment, then whatever they did accrue is going to carry over to their new school year.
Do the various rules under notice and use of leave eliminate our ability to discipline employees for absenteeism?
They don't limit or restrict the ability to discipline for absenteeism. However, they can't take into account, or they shouldn't take into account, or discipline somebody because they're exercising their right to use the earned paid leave. If they're meeting the notice requirements established by the employer, then they can't be disciplined because they're using their leave. Now, if they don't call out, if they're a no-call, no-show, they didn't notify the employer of an emergency, illness, or sudden necessity. They just didn't call, they didn't show up. And the employer allows them to continue to work. I mean, there's nothing prohibiting the employer from disciplining or taking some sort of disciplinary action on that employee for not providing the notice according to their policy.
Question from an employer. We manage our paid leave on a calendar basis, January to December. How should an employee who was hired mid-year be managed? Would they accrue their 40 hours during their first anniversary year, or do we prorate for the partial year and start over in January? Or do they accrue in their first anniversary year, then move to the calendar year the following year?
Right. Whatever the policy is, whatever they're going to establish as the year, there can be no, the employee can't lose any benefit that they would have had if they stuck with their actual anniversary date. So if somebody starts mid-year and the employer is going to establish the first of the year as anniversary dates going forward, whatever the employee accrued up to the first of the year needs to carry over into that year. And then from that point forward, they're entitled to a maximum of 40 hours. If they don't use it the following year, they're not going to accrue another 40 hours at the beginning of the year. But just changing that anniversary date, whatever they would have accrued from the start of their employment to that new anniversary date should carry over. It needs to carry over to that new anniversary date.
Yeah, we tackled that and we talked about it quite a bit when we were writing the rules. And like Scott says, what we came up with was to try to give the maximum flexibility to the employer to define what the year would be, but make sure that it just doesn't negatively affect the employees' leave opportunities. So if you look in the rules in the definition, if you look there, it's under section 2N, definition of year of employment. So what we tried to do is maximize the flexibility because we had quite a few questions in our listening sessions about that. Maximize the flexibility for the employer, but to eliminate any loss to the employee. So that was the purpose of that rule.
Next question. We have a ton of them, folks, so we'll keep slugging through. Our vacation and sick policy is not earned time, but granted time per year. Also, it does it qualify for the earned leave time off? Also, our sick policy is not paid out at termination, but our vacation policy is paid out on termination. Is the earned paid leave required to be paid out?
Okay, so in that last example you gave where there is no payout of the sick time, but there is payout of the vacation time. There's no earned paid leave policy established. The terms of the vacation policy apply to the earned paid leave. Now, I'm not sure what they mean by we have a policy that's we grant the time, but it's not earned. If the total amount of time that's granted meets the basic minimum of 40 hours that the employee can use for any reason, then that policy probably meets the standard. They wouldn't have to create a new or offer another benefit on top of what they're already offering that meets the minimum standards of the law.
The law says employees get up to 40 hours in a defined year. What is the definition of a defined year?
A defined year. So our rules define it as a 1 year period, meaning any period of 365 or 366 days in a leap year, consecutive days. Okay, so 365 consecutive days is a defined year. The employer can say your defined year is from your anniversary date to anniversary date. Or in the case, the example you had earlier, somebody gets hired mid-year, but now the employer is going to establish the anniversary dates as the beginning of the year. The defined year, in that case, would be January 1st to December 31st.
It's up to the employer as long as the employee doesn't lose any leave.
That doesn't lose a benefit.
This, I believe, has to do with the threshold for qualification. Does the 10 employees need to be W-2 employees, or would 1099 employees count as well towards the threshold, I'm assuming?
Okay, so first off, the threshold is more than 10. Okay, so it's going to be 11 or more. And W-2, if they're defined as an employee or meet the definition of employee, covered employee under unemployment standards, then they are a covered employee. What we're going to find, or what's going to happen, is people are going to realize that maybe they have been classifying people incorrectly as independent contractors. And they'll have to revisit that. If somebody was incorrectly classified as an independent contractor, and unemployment determines or establishes that they are actually covered employment, that independent contractor is going to be reclassified as an employee, and anything that they would have accrued from the start of their employment is going to be, up to 40 hours is what they're going to be entitled to.
I don't know if Jeff or Michelle might want to take some.
Okay, thanks, Mike. I was going to say, we use from Title 26, Section 1043.11e, which we also refer to as the employment standard, is what we use to determine whether someone's an employee or an independent contractor. I would be happy to email anybody out there a copy of it. It's jeff.brand@maine.gov. If you email me, I'll send you a copy of that, or if you have any questions. But basically, they're going to have to pass that employment standard to be considered an employee. And just briefly, there's 2 parts. There's 5 parts to part 1. You have to pass all 5. We don't even need to consider 2 if you don't pass 1. Then if you do pass 1, then you need to meet 3 of the 7 criteria. But in Section 1, we're looking at things like, does the individual have the right to control the means and progress of the work, except as to the final results? So if you're telling them to show up on the job site or at work at such and such a time, if you're setting their pay, they're using your tools, that's probably not going to meet that. Then the second part is the individual is customarily engaged in an independently established trade, occupation, profession, or business. And what we're going to be looking for there is, are they giving you an invoice? Do they advertise? Do they have a website? Are they out there looking for work? If you hired them, could I also hire them? C is the individual has the opportunity for profit and loss as the result of the services being performed for the other individual or entity. It has to be more than just, you'd have to be able to, and I should say the burden of proof is upon the employer, not the individual. So you got to be able to show us that they could either make money or lose money by doing this job. If you're paying them a straight hourly wage, that's going to be questionable. We're going to look pretty hard at that. The fourth is, do they have the right to hire assistance if they need assistance? And then the last is, is kind of similar to B, but are they holding themselves out to the public to do this type of work? So if they don't pass any of those, then we are going to consider them to be employees.
I think the upshot, and thank you, Jeff, is, and not just for reasons of earned paid leave, but for a large number of reasons, it's very important to properly classify your employees or independent contractors. And if you need advice to do that, you should definitely contact us. And probably the Bureau of Unemployment Compensation will give you the guidance that you need. Is that fair to say, Jeff and Michelle?
It is, and we can be reached also at 207-621-5120.
Thank you.
We're supposedly got about 10 minutes left, but I'm gonna hope people can stay on a little longer because we still have quite a few questions. So I'm gonna try and buzz through some of them here. if the employee requests payout of unused earned paid leave at the end of the year, does the employer have to do that? Or is that just at the discretion of the employer?
Yeah, that's at the discretion of the employer. If they do pay it out, the employee is going to have nothing at the beginning of the year, and they're going to start accruing again.
If an employee is per diem and only works less than 120 hours in a year, do they accrue?
Yeah, okay, so if they work, the number of hours in a year that they work is irrelevant. It's the number of days. Well, they're going to start accruing from day one, and it's 1 hour for every 40 hours worked. So if it takes them 6 months to work 40 hours, it'll be 6 months before they've earned or accrued 1 hour of earned paid leave.
But they don't have the right to use that leave until they put in the 120 days.
Correct.
Right? There have been 120 days since they started.
Yep.
If the employee's employment is terminated before 120 days are up, are they entitled to the earned paid leave accrued?
If the employer has an earned paid leave policy that dictates that the accrued time is paid out, then it needs to be paid out. If they don't have a policy and they have a vacation policy that dictates it's paid out, it's got to be paid out.
Even if they haven't been there for 120 days?
Right, they've accrued it. They haven't been able to use it. They don't have to use it, but they've accrued it.
Okay.
If they don't pay it out and they return to work within a year for that employer, that balance does carry over.
How does this apply to salaried employees?
Salaried employees, so salary is a term that may be misunderstood or is misunderstood frequently. Salaried exempt workers that are blue collar workers, they are presumed to work 40 hours a week unless there's an actual time record for that individual. Okay? So if the salaried employee, the state employees, whether you're frontline worker or your administration, you keep track of your time. So if you're keeping track of a salaried employee's time, even though you pay them a fixed amount, regardless of the time that they work, if you're keeping a time record, they're accruing at whatever they're actually recording for hours. If there's no hourly records, they accrue 1 hour for every week worked.
I think that we know the answer to this question, but what if, I believe it means current policy only allows you to carry over 24 hours. So you would have to, in other words, the current policy of, I would assume, of leave is 24 hours. You'd have to add an additional, what, 14 onto it?
Yes.
Yeah. We have a policy in which we front load sick time in January, say 40 hours. They have 40 from the year before unused. Does this need to be rolled over to 80?
Not according to the statute. Yeah, right.
Sick time policies, or you can establish anything. If you don't have, if it's only a sick time policy, that isn't going to meet the requirements of the earned paid leave. Okay. It would go back to your suggestion that employers seriously consider combining everything into a PTO bank and carry over. But sick leave in and of itself doesn't meet the requirements of this law.
But if they were to front load general earned paid leave that met the requirements of the law, they would not have to roll over more than 40 hours to the next year.
Correct.
Right.
What is the reason to track the employee's, what is the requirement to track the employee's reason for leave, if any?
There is no requirement to track the reason for leave. It's just saying that the employer can, if the reason for leave is for an emergency, illness, or sudden necessity, the employer can't require advance notice. If it's for anything other than illness, injury, or sudden necessity, the employer can require up to 4 weeks advance notice for use of the leave.
I think you answered this. I'm going to ask it one more time because this came up a lot during the listening sessions. Is the defined year a rolling year based on hire date or calendar year?
It can be either, as long as the employee, if you change it from the date of hire, as long as the employee doesn't lose the accrued benefit if it's changed to a calendar year.
Does time count against attendance if unscheduled or scheduled time off?
They can't take adverse action against an employee for using leave for an emergency, illness, or sudden necessity without giving it, which doesn't require advance notice. You can't reprimand somebody for using leave under this law, but you can reprimand or have some sort of discipline action for an employee that's not meeting a notice requirement established by the employer. So the employer says, if you're going to be out for an illness, injury, or sudden necessity, you've got to at least notify us as soon as practical under the circumstances. So if you had a flat tire and then you just don't tell the employer until the next day, it's going to be, the employee is going to have to give some sort of reason why they've never notified the employer.
Or if the requirement were for 2 weeks notice for voluntary leave for vacation or whatever, and you only gave them 1 week's notice, then that would be a possible reason for disciplining the employee rather. Is that correct, Scott? That
Yes. Yep.
if the employee doesn't meet the allowed requirements of the employer, there could be.
I'm not completely sure I understand this question, but we have vacation accrual on a prorated basis for staff working 20 hours or more a week. If they have accrued time, do we have to give, I think she meant them, additional time under this law? I mean, there's two different things going on there, but go ahead.
Mm-hmm.
So if your policy limits the accrued time to only 20 hours, they're going to have to they're going to have to change their policy to at least 40 hours if they don't have a separate earned paid leave bank.
I mean, the other thing I picked up on is that staff working 20 hours or more a week. This law applies to any employee who was working, regardless of how many hours a week. I mean, it's not limited to you only accrue if you work more than 20 hours. You're
Correct.
accruing this leave if you work 5 hours a week, basically.
That's right.
Correct.
But your earned paid leave accrual is determined by how many hours you work.
Right.
So it'll take you longer to get a day off if you only work 5 hours a week, but you're still entitled.
And this is, again, the point being, this is full and part-time employees are entitled to this leave under the law.
Correct.
Yeah.
Let's see. Does the time an employee is out of work for FMLA considered time worked for accrual of paid leave, earned paid leave?
Okay, so they're not going to accrue leave when they're out on leave. It may count towards the 120-day period. So if somebody begins work and they're out after 2 months of work, and the employer allows them family medical leave or leave in that shorter period of time, they're not accruing any additional time, but what they did accrue stays with them.
Do employees earn paid leave in partial hour increments? For example, an employee earns 1.25 EPL hours for working 50 hours, or do they have 1 earned paid leave hour until they get to 80 hours when they would be at 2 hours?
Right. I guess it's going to depend on how accurate or how precise the employer's timekeeping system is. The employee is earning 1 hour for every 40 hours worked. If they worked 60 hours, it earned 1.5 hours. The employer, I may have to think about this one. If the question is, do we have to afford them the opportunity to use 1.5 hours because they've only worked 60 hours? I think, Initially, my thought is no, because they haven't accrued 2 hours. They've accrued 1 hour at that point. But we'll have to, it's
Yeah.
the question that we'll have to
As you
discuss.
can tell, I think you've found a question that we hadn't considered, or if we did, we didn't come up with an answer. So we will work on that.
If you begin work on January 1st and work 40 hours a week and take all 40 hours allowed to you, is it correct to assume you do not accrue any time for the final 12 weeks of the year?
Correct.
So if an E earns the full 40 hours by, say, July 2021, the clock stops counting at that point and does not begin again in 2021 or 2022 until the original 40 hours have been used up.
Right. They're going to
define the year. Yeah.
Some employees are going to accrue time really quickly because they work a lot of hours. Accrual stops once they reach 40 hours. So if they've reached 40 hours by the middle of the year, they're not accruing, they don't continue to accrue hours to the end of the year. If they didn't use any time and now it's a new year, they're not accruing an additional 40 hours. That 40 hours from the previous year carries over.
What, if any, is the time frame to capture the number of hours worked if staff hours fluctuate week to week?
Can you read that one more time?
What, if any, is the time frame to capture the number of hours worked if staff hours fluctuate week to week? I mean, I think it's based on their time card or something if they're an hourly employee or whatever.
Right. An
Whatever
employer is required to keep true and accurate daily time records. It doesn't matter if they work, 1 hour a day or whatever the case may be.
Can an employee who wishes to give notice to their employer use the accrued EPL as being one of the 2 weeks of notice?
I think that would be at the discretion of the employer. So the employer has a policy, you've got to give us a 2-week notice. The employee says, okay, I'm giving you a 2-week notice, but one of those weeks I'm using earned paid leave.
Go ahead.
Question that we considered when we were thinking about payout requirements, and for instance, and it's not a requirement that the employer offer to pay out whatever leave is accrued, but to avoid having that happen, an employer might want to consider having a payout policy, so that in the last week of their employment, an employee doesn't call in sick using their earned paid leave. Does that make sense?
Yeah, so an employer could establish a policy that if they have a policy that says you've got to give a 2-week notice, right, and you have to actually work those 2 weeks, that doesn't conflict with the law, so that it wouldn't be a problem there.
If an employee gets PTO in sick, personal, and vacation that exceeds 40 hours in a plan year, but it's not front-loaded this time, does that satisfy the earned leave requirement, even if not front-loaded?
If it's not front-loaded, they have to be able to use it at a rate of what they've accrued at 1 hour for every 40 hours work.
This is from another seasonal employer. We are a year-round business. However, we hire a large number of seasonal summer employees. As seasonal, do they also accrue 1 hour for every 40, even though there is a beginning and end date of their employment? Also, does this affect our international seasonal team members?
So seasonality is going to be the question for Jeff and Michelle. If they are bona fide seasonal employees working at a seasonal business, or deemed seasonal by unemployment standards, the earned paid leave law does not apply to them.
Yes, so I would say if they are only a seasonal employee, if they're not working outside of that seasonal time period, they're only a seasonal employee. They can't extend beyond that and get paid as a non-seasonal employee during the rest of the year. If they're only a seasonal employee, then they would only be reported as seasonal. And from what they've said, they would be looked at as just a seasonal employee. And it would only apply to the ones you're reporting year round outside of that seasonal time period as well.
And to answer the last part of that question, the seasonality standard would be determined regardless of whether they're international, whatever that means. So I guess foreign guest worker or otherwise. The same standard would apply, right?
I would just jump in there and let employers know that the international workers are it's complex and it depends on their visa type. And I don't off the top of my head remember which ones are reportable for unemployment and which ones are not. So it's going to be important to know what their visa type is.
Okay.
As to whether or not they're reportable for unemployment tax purposes or not.
And Jeff or Michelle, how would an employer go about making that determination?
I believe they have paperwork
Okay.
that informs them of what their visa is.
Okay.
I'm going to ask this question because it came up a lot again in the listening sessions. If we have a per diem employee who has no set work schedule week to week, does the employer just track hours worked until the per diem employee racks up a total of 40 hours, whether in the same calendar year or it takes the employee into the new year to reach the cap of 40 hours?
Scott?
Yeah, so a per diem employee that has no set schedule, the employer still needs to track their hours actually worked. And they would accrue 1 hour for every 40 hours worked if it took them, no matter how long it takes them to work 40 hours.
And it would roll over, if not used, it would roll over into the next year.
Yes.
We have a follow-up on the discipline question. I understand the requirements for notification. Our policy also covers volume of unexcused, and then in parentheses, in essence, unscheduled missed time. We start discipline warnings at 40 hours of lost time in a six-month period. Would we need to reframe our policy?
If the employee is following all the terms of your policy for advance notice, you can't discipline them because they used time. If they're not following the policy for giving notice as soon as practical under an emergency, for emergency purposes, they shouldn't be or can't be reprimanded because they're exercising their right to earn paid leave, as long as they're meeting the notice requirement, meaning that they're notifying the employer as soon as practical under the circumstances. So an unexcused absence may be an unscheduled, depending on how they define an unexcused or unscheduled absence. If somebody has a flat tire or has no child care for a particular day and they notify the employer as soon as possible, the employer can't reprimand them because they're exercising their right to their earned paid leave under those circumstances.
We have a PTO policy that grants employees 40 hours for the first year of employment. We currently accrue it as 0.77 hours a week. Do we need to adjust the policy so we accrue it quicker?
You have to, they've got to accrue at a minimum of 1 hour for every 40 hours worked. If they don't work 40 hours in the week, but they're accruing more than 3/4 of an hour, that could exceed the standard. But if they're working more than 40 hours, but they only accrue 3/4 of an hour time, that's not meeting the standard.
Yeah, I think the short answer is yes. They do need to adjust their policy.
If an employee says they have a fear of COVID, but no positive test or being near anyone who is COVID positive, can the employee use their accrued earned paid leave to take time off since they don't qualify under the FFCRA law? Yes, I would say yes.
Yeah, that would probably qualify under emergency illness or sudden necessity. And, you know, if that came, if a complaint was made of that sort, I'd have to get all the facts. If it's basically, I can't work because I'm worried about COVID in this environment, and they do have time available, the employer would have to allow them to use that time that they have accrued.
This is another good question, and again, heard some of this from municipalities and schools during the listening sessions. If an employee holds an hourly position plus coaches and is the advisor for a student club, would they accrue under each position?
Some of those positions might not be employment. There are times when somebody can be a science teacher in a school, but now they're going to, they've volunteered to be a coach for a team. Potentially that time coaching is not employment. If they're paid for all of those hats, then it's employment, and all of those hours would be tracked and count towards the accrual of earned paid leave.
I had a hard stop for myself at 11:15, so we're going to do 2 more questions and we're going to call it good. What if an employee works 60 days over the course of the summer, then returns for a few days in December? 120 days have passed since they began employment, but are the days when they are not working, September through December, included in the length of employment?
If they return to work within the year, then that clock is already ticked by. Those days do count. I mean, they didn't accrue when they weren't working, but the 120-day period has already passed, or it could have passed.
So let me break that down again. The employee works 60 days for the summer and then departs in August. They don't work again through September, October, and November, but in December for the holidays, they return and they work. What is the status of the time between September and December? That they didn't accrue any time because they weren't working, correct?
Correct.
They weren't employed during that time.
Correct. So does that count towards the 120 days? They've only worked 60 days. That doesn't count towards the 120 days, but the accrual period would restart once they started in December actually working, correct?
Both the accrual and the count, I think, of whether they've worked 120 days and are entitled to use their leave. And I'm going to check with Scott to make sure that makes sense, because it's 120 days of employment.
No,
Right.
It's 120 days from the start of employment.
Yep.
If they return within the calendar year. So yeah, we're going to have a
conversation about
conversation on this one.
Yeah.
So,
Yeah.
again, it's another frequently. Yep, it is.
That's it, because that will, in the retail world or the restaurant world in particular, you can see that happening.
Yep.
Another educator question, and it'll be the last one. We have adjunct instructors, which are part-time exempt employers. As exempt employers, are we okay to use the IRS hours equivalents like we do for ACA as a basis for their hours worked?
Scott?
Yeah, nope, I'm trying to wrap my head around the question. They're an adjunct instructor. They're paid how?
Which are part-time exempt employees.
Okay.
Are they okay to use the IRS hours equivalents like they do for the ACA as a basis for their hours worked?
So part-time, full-time is irrelevant. If they're exempt and they're paid a salary, they're presumed, if there's no actual time record captured for the actual hours worked, the presumption is 40 hours worked. If both the employee and the employer are in agreement that, look, I only work 20 hours a week, then that's the number. So we would use that number. So potentially, yes, we could use the numbers that the IRS use.
We just require that there be some record, right? Or we default to a 40-hour week. Is that correct, Scott?
Right. Absence any record, it's presumed 40 hours. But if there's no conflict between the employer and employee as to the number of hours that they're actually working, we would use that figure. If there is a conflict, the employer is saying, you only work 20 hours, and the adjunct instructor says, well, no, I'm actually putting in 40 hours a week. Absent a record, it would probably be presumed 40 hours a week.
Right.
This is where the investigation would have to ask a lot of pertinent questions and try to gather as much detail or facts as possible to make the determination.
Yeah.
So I lied. I'm going to squeeze one more question in because it deals with it, something coming up, the ski season. Yeah. Ski seasonality is November 15th to April 30th. If the staff member is seasonal, are they exempt from the earned paid leave?
If they are seasonal according to unemployment standard, they are exempt from earned paid leave. The issue arises if they work outside of the season. That's what an employer really has to pay attention to. What is their established season? Is that worker starting early, or are they working later in the season? That could affect the outcome of the answer for earned paid leave.
Yeah, Michelle or Jeff, is there anything different about ski season, ski industry seasonality that you would want to talk about? No.
No, and that is the set season for the ski industry. So as long as they're working inside that period and they are just a seasonal employee, then they would be looked at as seasonal, and anybody outside that would be looked at as regular.
Okay.
Okay, that's going to do it, folks. And I really want to thank Mike and Scott and Jeff and Michelle for all the questions. You guys, I don't know if you've seen the chat, but there's been a lot of very positive comments, people thanking you for your time and the knowledge that you brought here this morning. And that's been very important.
Can I just ask one thing? Can you get us a copy of all those chat questions? Because we got some work to do here.
Yep.
I can ask. Only Angie will know that. Angie?
Yeah,
Okay.
we get a transcript of the chat at the end, so I'll save that and send it along to you, Peter.
Wonderful.
Okay.
Thank you.
For all the folks that are on here, you should know that this is recorded, so you can go back. We will post a link to our website, and you can go back and view it. You should also know that the Department of Labor has scheduled additional multiple sessions on their end, and we will promote those on our website, on our Facebook page and social media, so we can drive people there who have additional questions. And Mike and Scott, we're glad to help in any way we can. Deeply appreciate the four of you joining us this morning. I also want to thank, again, Bangor Savings Bank, Central Maine Power, and Eden Peabody for their sponsorship. I hope folks got a lot out of this. We certainly had a packed house this morning. So thank you all very much, and please stay safe.
Thank you.